evening, welcome to my YouTube channel. My name is David Okon. I'm talking about in the UK, I'm talking about work. Work is a source of success. As I said previously, watch this video and the rest of the video, and they are an extension. So we are looking at work, we are looking at how to calculate pay, and also looking at payments. We look at the date, we do the calculation, we look at certain limits in terms of calculating, and we look at employees with respect to paid for paying a fixed wage or a salary, or looking at an entire pay on an hourly rate. We are going to look at our employees are also paid by piece rate, variable bonuses, and commissions, and looking at shifts, rotas, rota workers. These are different elements adjusting pay for work done outside normal hours. We are also looking with employees with no formal working hours, and we look at work done for a previous employer as well. And this document is based on the former Department of Trade and Industry leaflets on continuous employment and a week's pay. So the rules for calculation of URN 06 stroke of 531, which is, leave a comment below if you know all those units, which is no longer available. So this is a document. This document does not apply to calculating a week's pay for the purposes of holiday pay. So we're looking at how employment pays in the United Kingdom, looking at work, and we explain this document explaining what legislation means by week's pay, entitlement to redundancy pay, guaranteeing pay and some type of compensation awarded by employment tribunal, and also during notice and during time off for job hunting and for antenatal care, where these are all related to an employee's pay week, a week's pay, which is defined as the amount of pay the employee is due per week under his or contract of employment. This is not necessarily the same as average pay or a pay in a typical week. So we're looking at paragraphs here and explaining how to work out the week's pay under this definition. So you calculate the date, as we said previously, looking at the introduction, the legislation set for the purposes of many individuals' rights. The table listing them, also showing the date at which the week's pay should be calculated for the purposes of each right, known as the calculation date. Also noting the calculation date, where relevant working of working out, or the relevance of working out a week's pay, which may well be different from the qualification date, which need to be worked out, working out the length of continuous service, and which is given in the documents which I'm looking at here. So you're looking at certain limits on as to rights being shown in these tables, the payment as they are awarded, which are subject to financial limits, which are set by the regulations. These limits are reviewed annually. If you live in the UK, leave a comment below. Employees are being paid a fixed rate or salary entirely on an hourly rate. This is also where an employee's pay for work done in normal working hours does not vary. A week's pay will be the pay due for the basic hours the employee is contracted to the work. As in relation to in link with how contract is set. For any regular bonus or allowances except an expenses allowance, which does not vary with the amount of work done, may be included, but pay for overtime hours may only be included if the contract of employment obliges the employer to provide those hourly hours in the overtime working, as well as the obligation of the employee obliging the employee to work overtime if the employer provides such an opportunity. So we are now looking at also employees paid by piece rate, variable bonuses, or commercial commission, or on a commission basis. We are looking also to see if an employer's pay varies with the amount of work done. As for example, under piecework system, or when pay is virtually made up of various bonuses or commission related to output performance, then a week's pay for normal working hours, including overtime hours, are not binding on both sides, as above is on a specially calculated hourly rate. This rate is the average hourly rate over a 12 weeks period ending on the calculation date, if the calculation date is the last day of the pay week. If the calculation date falls during a pay week, the 12-week period ends on the last day of the previous week. To get this special average hourly rate, only hours when the employee was working, including overtime hours, can be taken into account. Now, if the employee has less than 12 weeks service, other factors might be relevant, such as the working hours of the employees of some or of the same employer, and or the expected pattern of working based on the terms on which the jobs was offered. Any pay for the hours not worked, for example, under a guaranteed weekly agreement, must be left out. If overtime hours are included, the pay must be adjusted as explained in paragraph 8 below. Any week in which no work was done should be replaced by the last previous week when the employee did work, to bring the total number of weeks up to 12. 12 out of 13 of any quarterly bonus, or 12 out of 52 of any annual bonus can be included, provided the bonuses are not paid specifically for some time outside the 12 weeks period. So the hourly rate is calculated by dividing the pay to be taken into account over the 12 weeks period by the number of hours worked during the same period. Look at shift or rota workers. If at the calculation date the employee is contracted to work at normal hours, but on days of the week or at times of the day which differ from week to week or over a longer time, so that the pay for any week varies. For example, when the normal hours worked at night or at the weekend attract a higher rate of pay, then the week's pay means the pay for the average number of normal weekly working hours at the average hourly rate. To allow for the variation of hours according to the shift worked, the average number of normal weekly working hours is calculated by dividing 12 by 12, the total number the total number of 12 weeks ending on the calculation date, if the calculation date is the last day of the week. If the calculation date falls during the pay week, the 12-week period ends on the last day of the previous pay week. The average hourly rate week is worked out in the same way as the piece workers explained in paragraph 6. Adjusting pay for work done outside normal hours. Work done outside normal working hours, for example, voluntary overtime, will sometimes be included in arriving here at the average hourly rate. A 2016 Employment Tribunal ruled that regular voluntary overtime, standby, and call-out pay should be included in the calculation of holiday pay, white or others, versus Adelaide Metropolitan Borough Council in 2016, and so on and so forth. This was in 2015, the case which actually addressed this issue. Where pay for such work is higher than pay for the same work done in normal working hours, the pay must be adjusted, that is to say, brought down to the level it would have been if the same work had been done in normal working hours. If there is more than one rate for work done in normal working hours, for example, because the hourly or piece rate goes up after a certain number of hours have been worked or units produced, the overtime pay should be brought down to the lower of the normal hours rate. So we are looking at employees with normal working hours. For an employee with no normal working hours, for example, an outdoor sales representative paid wholly by commission, the amount of a week's pay is the average weekly pay for over a week, a period ending on the calculation date, if the calculation date is the last day of the week. If the calculation date falls during a pay week, the 12 weeks period ends on the last day of the previous pay week. Any week for which no pay was due should be replaced by the last previous week for which pay was due, so as to bring the number of weeks to be averaged up to 12. Let's look at work done for a previous employer. Weeks worked for a previous employer can be included in a 12-week period over which the hourly rate is calculated if the exchange of employer did not break the employer's continuity of employment. So the rules of calculating a week's pay, as we can see, if you visit gov.uk, then you get a breakdown of the tabulated statistics, which we are going to skip for purposes of this program, visiting gov.uk or any of the other website to see the figures. Continue watching, stay tuned.
MVC record.
Bravo, Jesus, on the beat.
Continue watching. If you are watching from the United Kingdom, then this program is for the UK, for workers in the United Kingdom. We are looking at employment and many factors affecting employment, including how it is paid, how it is various issues addressed. We are looking broadly at the overview. We are looking at the overview aspect of this program, and also if you are outside the United Kingdom, what happened in the UK is relevant in your country. So it is important to follow what is happening in the United Kingdom, whether you are going online or whether you are listening to a video such as this, because I have said previously, I'm also repeating now, that it is very important for an individual or of the modern citizenship of the world to not really necessarily take life into their own hands, but as of necessity to take responsibility for their lives. I have also said the government is still helping people in many ways with their public sector economy, but if you have noticed and also having watched the rest of my video, you will find that the public sectors have been closing down. There's a squeeze and it's the political agenda across the globe to shut it down. If you're in Africa, you will be the first to notice that there have been changes there, where the public sector is increasingly being closed down. Therefore, if you don't have money, if you don't have access, if you don't have knowledge, more or less you're going to be excluded from the opportunities, from the resources of the world increasingly going forward. I have discussed this point overly, and please leave a comment below, and thank you so much everyone who have been supporting this channel, watching the videos, sharing with family and friends, clicking notification bell, clicking like, and also engaging in the conversation within this program. And I'm so delighted to carry on with this program going forward. I will be stopping from time to time to provide a piece of analysis here and there. I've looked at development and culture, and also how they inform and also conduct progress in a modern society. I'm so delighted that you came, and also carry on watching. We are going to continue with employment. Employment is part of work, and work can be employment, can be self-employment, can be part-time, can be apprenticeship, can be any other. Watch this video and the rest of the video, and you will make more sense. I will be from time to time stopping to provide some reflection. So right now, continuing to watch, we are going to look at employment status. This is a specific legal and policy material here in the UK. Like I said, because of globalization, what happened in the UK is replicated more or less across the globe. And therefore, if you live in Europe or America and in the other continent, pay close attention to what happened in the UK, take responsibility for your life. If you live in abroad and you also want to work in the United Kingdom, immigration aspect of employment law or working law is quite important for you. And if you can do a research, visiting gov.uk. That's the government website in the UK. It's similar to the kind of website for government in your country. So it is so important to be self-reformed in the 21st century, because going forward, you and I will be required by the government, also by necessity, to be independent, to be empowered. So information is strength and power. That is part of the function of these programs. Let us look at these specifics about employment status, and checking your employment status as it is. And so for dealing with a problem at work, also needing to check what right you might or might not have while trying to enforce some of the rules in your favor or otherwise. Then you are checking what employment status you might have to claim that right as it may be available in terms of options. So you might in one way or the other be trying to enforce more than one right. You might need also to check your employment status for each one of those rights. Often it is clear what you might be having as of rights in terms of employment status, and it also what it may also be not really very clear what your rights at work may be. But sometimes you will have to look more closely at your actual working arrangements to work out your employment status and rights. So in other words, things may or may not be always clear. Such a situation available with the legal principle and rights it gives in terms of what you might or might get as protection or benefit. Therefore, your working arrangements might be different in practice from what is in your actual contract. So keep an eye always if you are dealing with this type of situation. So you might be an employee worker or self-employed, like I said previously. Sometimes an employer might also say something. An employer might also say something which is self-employed when you are really a worker or an employee. So it's a tricky situation as always, and the law, especially of employment, being all the more even trickier. So you might do, they might do that deliberately or by mistake. And if you are in a situation where your employer disagree about your employment status, then a tribunal or a court will have to decide. You will have to look at your actual working arrangements as well as other contract or other documents which are actually yours in relating to your working and on all the other aspects. So you can actually look at certain information on different types of employment status, like I have said previously on gov.uk. So there are certain questions you might be called upon to check in relation to employment status. Therefore, you might also need to consider a number of things which work out your employment status per se. So in certain situations, you necessarily look at all the terms of the agreement between yourself and your employer, as it may be, in terms of, for example, workplace practices and how you actually do the work. So you may be doing one thing and also looking at what normally happens in your place of work, and also what may be written somewhere else as a directive of what may or may not amount to your employment status. So there are maybe practices which might be different from what you really agreed in writing as to contract. So a written statement on terms and conditions in this is also called Section 1 statement or a contract of employment. Every time you hear something resembling Section 1, that is the law in relation to that issue also covering certain rights. Checking also at the same time someone who might be an employee, and so you may be likely to be an employee if there is an obligation on the employer to give work to someone like yourself, and also for you to actually be able be required to do certain work. So there's a form of directional or directive from your employer in terms of a day-to-day task, and also whether or not they have control over you are an employer, but whether the processes of work is controlled by employer. For example, if the employer have control when and where and how you should be working. So these are some of the finer details where you seek to establish certain processes and in seeking to identify certain rights or obligations. So you may also have an obligation being placed on you by your employer to do work yourself. For example, you cannot ask someone else outside the business to do the work instead. These are some of the elements, some of the features of trying to identify whether you have one type of employment status or another. So these three factors are the minimum needed for you to be an employee. If you are trying to define your status as an employee as opposed to other elements of employment. So if you have checked these elements, these functions, then you are still not sure, then you are an employee, and if you are an employee, you will need to find out more information to be totally sure. And if you are likely to be an employee, you are as always, you will be likely to be an employee if some of the following applies, checking further to establish that you are an employee or otherwise. So when you get a regular wage or salary, this is the payment for your work. And if you are subject to employer's grievance and disciplinary procedure, if you work fixed hours and have regular work, and if your employer can dismiss you and if your employer pays your tax and pays your tax and national insurance. These are features to indicate whether or not you are an employee, and also when your employer provide the tools or equipment needed for the job, for example, a computer or a builder's tool. If you are sick, you get sick pay from your employer, a holiday pay from your employer, a pension contribution from your employer, and that is an indication that you are an employee. If you are in an employee, if you are an employee, you will have the statutory rights of employees there. So you can check this on gov.uk whether or not you have rights as an employee. Like I have consistently say, leave a comment below, let me know what you think about this process, so you can check if someone else is a worker, because there is an employee and a worker in terms of employment status, like I said previously in the openings. So if you appear to be an employee, or if you are actually an employee, you will also automatically be a worker. So an employee is necessarily a worker, but that may also mean that a worker is not necessarily an employee. Give a comment below if that makes sense to you. So you should look at how your relationship with your employer works in practice. So you are likely to be a worker. We are looking at worker as compared and contrasted with employee, and if your contract says you are to do the work yourself and cannot pass it on to someone outside the business without your employer's consent or agreement. So another element to look at is when your employer is in a client or a customer of the business you are working for that such a business. For example, if you run a business providing IT support to other businesses, that is an example. And also if you are subordinate or dependent on the employer, for example, if your employer decides how the work is done on what terms, and also if you you have a right to send if you have a right to send someone else to do the work, then you should check also that it is a genuine right, and also that it won't be genuine if the contract says you can send a substitute, but in practice you cannot actually do that. So you check on those final details. So if you can only send a substitute under certain conditions, for example, if the employer has to approve that person first, then you might be a worker other than something else. We're probably looking at self-employment. If you have to send someone else to do the work when they are probably self-employed and not a worker. So these are some final elements of employment law and policy, and also to do with employment status. If it is not clear if you are actually a worker, you will need more information as always. So you will always likely be a worker if your employer under these circumstances is recruited then to be part of your their businesses. You paying tax or national insurance contribution. If the employee is also one in charge in the working relationship, for example, because they say what you have to do or how much you get paid, and also the disciplinary procedure when they discipline you if they do something wrong, then your employer is the one to stand in the disciplinary conduct against you as an employer, or as a worker, or as a self-employed, whatever the case may be. So the lines can be fine, and you need to really pay close attention. If you are a worker, you will have a statutory rights of workers, as always checking this right of workership on gov.uk. So there are also some special employment rights for agency workers. So we're looking at the agency workers, examining the same. So you can check if someone is self-employed. You are likely to be self-employed if your employer is your client or customer, and also normally if they need to have a written commercial contract or contract for self-employment, and also if they run if you are run your own business, and also if you can send someone else to do the work on your behalf without restriction, and therefore this may be signs that you are self-employed. So if you use your own equipment, for example a laptop or a builder's tool, without your employer having to provide that, you're more likely than not to be self-employed. And these are how to find out whether you are one employment status or another. So you can choose also how you work, for example setting your own hours or working from home. You are responsible for the profit or the loss of your business, not your employer. So that is what your self-employment may look like in law, and also in terms of certain rights or lack thereof. If you're bogus self-employment, which from time to time happens because employment environment is not tidy, can be very messy. So an employer may claim you to be self-employed to avoid paying tax or national insurance contribution. These are common problems giving you employee or worker employment rights like redundancy pay or sick pay. And they may also do that, and they may also even if you have a written even if your written contract says you are self-employed, your working practice may show you are not. So keep an eye, and we live in an age where you have to be independent and empowered, because employment law, and especially if there is dispute, it is extremely expensive. You may not be able to pay even for information to be collected for purposes of examination. It can cost thousands of pounds. So if you do your own homework, if you're working, if you're not working, because you might start working if you're a young person leaving university, you may start working sooner or later. So if you can, in your spare time, you visit these websites and do a study of how employment law works in practice. So gov.uk is the good one for self-employment on this occasion, as we are looking at what really counts as self-employment. You can check on gov.uk. Gov.uk is the government website in the United Kingdom, but it can also be gov. somewhere else, maybe US or USA. Check accordingly in the country you live in, especially if you're in Europe, because laws in the UK is quite similar to laws in other countries in Europe and also in the Western world, but increasingly also in Africa. Africa is developing very rapidly, and also in terms of infrastructure, within law, within also the economy, politics, civil system, not to mention military system. So there is globalization, urbanization. I've mentioned these concepts increasingly. I'm glad I am doing the mentioning, because as I see these things again and again, we as a community on this platform become more familiar with what we are talking about or what we might not be talking about. Thank you so much for watching this material. Continue watching. Stay tuned. stay tuned, continue watching. We are looking at employment status in the United Kingdom, and now we are looking at self-employment or a possibility thereof, because these employment status, as you may or may not have them, carry certain responsibilities and rights, and therefore it is really important to know. Let us continue watching. Thank you so much, everybody who have been watching the videos, sharing with family and friends, and also subscribing if you are still new. If you are already subscribed, thank you so much. And let us continue looking at this material. If you are in the UK, if you are out of the UK, it's quite similar across the globe. Visit gov.uk and look at information and employment. We are specifically looking at possibility of employment status in the self-employment aspect. So if it looks like you are actually self-employed, then your contract will define the rights you are entitled to, like I just said. So you may also be entitled to certain statutory rights, like protection from discrimination, because the definition of employee is very broad in discrimination law. Other types of employment status also can be examined. Less common employment statuses are director and other holders and other office holders. Directors or office holders can also be employees or workers of their own companies. You can also read more about these different types of employment statuses on gov.uk. Like I said previously, check on the government website in Britain and also in your country. They may or may not be similar, but more similar, I believe, than not. So the next step is for you to take a look at and also talk to your employer to try and resolve the situation. If there is dispute, if this is not successful, you can look at you can look at taking your case to an employment tribunal. If I talk about you, I'm talking about somebody who is going to do it themselves, but you can get the help from professionals from other aspect of the service as actually a support mechanism in the United Kingdom and also in the country where you are. If you need help with working out your employment status or what step to take next, you can contact your unemployment expert. That's like I said. Continue watching. Thank you so much. Let us look at rights of part-time workers. And you can look at who counts as a worker under the part-time workers regulations. These are the laws. Who does not count as a worker under part-time regulation, workers regulations? The definition of a part-time worker, statutory rights of part-time workers or part-time employees, contractual rights of part-time workers. Stay tuned. Thank you so much. Stay tuned. Continue watching. We're looking at definition of part-time worker, statutory rights of part-time workers and part-time employees, contractual rights of part-time workers. You're also trying to look at what a pro rata means in law and also in practice. So you can also look at the situation when can an employer treat a part-time worker less favorably. It will talk about issues of discrimination. We're also looking at specific census part-time employees entitlement review, which is actually new written statements of terms and conditions. You can also looking at how can a part-time worker enforce your contractual rights. Bearing in mind that a worker suffers a detriment, a worker can suffer a detriment or can be dismissed for trying to enforce their rights under the regulations. So you examine all these. You can look at a woman part-time worker whether she should take action under the regulations or under this or under discrimination law. These are specifics. Also, you consider whether employers must allow workers to move between part-time and full-time work, and also look at if employers tries to give worse terms and conditions to a full-time employee. Thank you so much. Continue watching. Stay tuned. You ask certain questions as to who counts as a worker under the part-time workers regulations, and individuals' statutory employment rights will depend on whether the employee or a worker. Workers have certain statutory rights, such as the right to be paid the minimum wage and the right to limit to a limit on the hours of their working week, with some exceptions, such as members of the armed forces. Workers are not entitled to other statutory rights, such as the right to claim unfair dismissal, because these rights are only available to employees. So you need to pay attention to your employment status at all times. Employees are particularly a particular type of worker and are more statutory rights than workers. For example, employees have the right to claim unfair dismissal, usually after they have worked for their employer for a qualifying period, and the right to statutory redundancy pay after they have worked for 2 years. Leave a comment below about this information in terms of the law on employment in the United Kingdom, considering whether or not the rights are actually appropriate or relevant. I've discussed this elsewhere on the videos. This is actually complementary to the other videos I have already discussed. So more about who has the right to claim unfair dismissal under the Part-Time Workers Prevention of Less Favorable Treatment Regulation 2000. All part-time workers will be entitled to the same contractual rights pro rata as their full-time comparable workers. If the part-time worker works in the public sector, they may be entitled to additional rights. For example, for the purposes of regulations as set out in the law, a worker is defined as someone who works under a contract of employment, that is an employee, any other contract, whether written or verbal, where the individual undertakes a pattern or to perform any work or services for someone else, and the other person is not a customer or a client of the individual. This includes workers except those who are genuinely self-employed. Continue watching, stay tuned. Thank you so much. So you have the definition above, meaning that the following groups of workers are covered by the part-time workers regulation, such as employees who work under a contract of employment, even if they have no written contract. You're looking at agency workers, home workers, casual workers, contract workers, crown employees, and members of the armed forces, other than those receiving the training provided for people in the reserve forces, members of the police forces. There is no age limit for making a claim under the regulation. They are set out in the law, and then the worker does not have to have worked for the employer for any particular length of time before they can make a claim. Therefore, let us look at, stay tuned, continue watching who counts as an employee. An employee is a type of worker who works under a contract of employment. More about how to check if someone is an employee. Who does not count as a worker under the part-time workers regulations. The part-time workers regulations don't apply to genuinely self-employed people. For example, people carrying out a business and doing work for customers or clients through that business. Look at the definition of a part-time worker. A part-time worker is defined in the regulation as a worker who is paid at least partly by reference to hours worked as opposed to a number of pieces of work done, and whose normal hours of work are less than the normal hours of work of a comparable full-time worker. That is in terms of a comparator. There are also special rules about who the comparator should be if the worker was previously working full-time and had started working part-time for the same employer. For example, a woman returning to work after maternity leave. So the comparable full-time worker is a worker who is paid at least partly by reference to hours worked as opposed to a number of pieces of work done, and who works whatever the usual full-time hours are, or whatever full-time hours are as defined by their contracts of employment. The full-time worker, in order to be a comparator for a full-time worker, must do all of the following as seen in here: working under the same type of contract as the part-time worker, and to be employed by the same employer, be engaged in the same or broadly similar work, have a broadly similar level of qualification, skills, and experience, work at the same workplace as the part-time worker, or if there is no full-time worker at the workplace, work at a different workplace but still do the same or similar work to the part-time worker. So we are looking at when making a comparison between a part-time worker and a full-time worker. The regulations set out a number of different types of contract. When comparing two workers, one full-time and the other part-time, they must both have the same type of contract and so fall within the same group of those listed below. For example, a part-time worker engaged as an apprenticeship cannot be compared to a full-time worker who is not an apprentice. They could only compare themselves to a full-time worker on the contract of apprenticeship doing a similar job and having a similar experience and qualifications. The different types of contract are employees who are not apprentices, employees who are apprentices, workers who do not have a contract of employment and so are not employees. Any other type of worker who does not fall into one of these groups are listed above, where it is reasonable for the employer to treat them differently from other workers because they have different types of contract to those above. Let us look at the House of Lords holding that the part-time firefighters have the same type of contract as full-time firefighters, even though there were some differences in their work. Part-time firefighters should therefore not be discriminated against in terms of sickness, benefit, or pension rights. It was held that the question of whether the two groups were doing the same or broadly similar work was one of facts and degree. A tribunal should look at the extent to which the work done by the two groups was exactly the same. If a large component of the work was exactly the same, a tribunal should then ask whether any differences between were so important that they would prevent the work from being regarded overall as the same or broadly similar. In this case, the fact that the full-time firefighters carried out some extra tasks did not prevent their work from being the same or broadly similar to that of part-time firefighters. Therefore, that is how an example of how you can identify whether a part-time worker should have the same right or similar right to a full-time worker in law. looking at agency workers, part-time agency worker may not be able to compare themselves to a full-time employee of the company, as it may be reasonable for an employer to argue that the agency worker's contract is of a different type to the contract of any full-time worker in the company. Stay tuned, continue watching. Thank you so much. It will also be for the tribunal to decide whether this is reasonable. Statutory rights of part-time workers and part-time employees. Statutory rights of part-time workers. Statutory employment rights are those given by law as opposed to those given under the workers' contract. Different rights are guaranteed by different statutes. Statutory employment rights for part-time workers, including the following, a limit on hours of work for most workers, with some limited exceptions, such as domestic workers in a private household. You're also looking at entitlement to paid holiday, for example, for most workers, with some limited exceptions, such as members of the armed forces and the police forces. You also look at entitlement to the national minimum wage for most workers, and rights not to be discriminated against. These are some of the features. Statutory rights for part-time employees. Statutory employment rights for part-time employees include those listed in the previous paragraph and the following. This is not an exhaustive list. For example, parental paternity, adoption, maternity, and shared parental leave, with some exception. You're also looking at a right not to be unfairly dismissed. In some cases, the employee will have to have worked for the same employer for a qualifying period. A right to notice of redundancy and statutory redundancy pay provided provided the employee has worked for the same employer for 2 years, and a right not to have an authorized deduction made from wages. Let us look at contractual right of part-time workers. Under the regulation, all part-time workers will have the same contractual rights as their full-time colleagues, unless the employer can show there are good reasons why this should not be the case. Contractual rights are rights given by the employment contract as opposed to those given by the statute. Examples of areas covered by contractual rights include rates of pay above the national minimum wage, including overtime, bonuses, shifts, supplements, company cars, contractual sick pay and sick leave, contractual maternity pay and leave and parental leave, holiday entitlement above the statutory minimum wage, occupational pension, contractual redundancy pay and rights, carers breaks and sabbaticals, access to training, staff discounts, and also staff access to share options. Part-time workers must also not be treated less favorably than comparable full-time workers by suffering any detriment from the employer, unless the employer can show there are good reasons this should be the case. Let us look at overtime. If a part-time worker works extra hours above their normal contractual hours, they are not entitled to any overtime rate to pay for these hours until they have worked the same number of hours in that week as a full-time worker normally works. If the part-time worker works extra hours but does not work enough extra hours to reach the normal full-time number of hours, these extra hours do not have to be paid at the overtime rate, and the employer can decide at what rate to pay these extra hours. This is the difference between part-time and full-time workers in relation to overtime pay rate. Once the part-time worker has worked the same hours the numbers of hours as a full-time worker normally works, any extra hours will be paid at the same overtime rate as a full-time worker would be paid. A part-time worker usually works 20 hours per week, and the equivalent full-time worker works 40 hours per week. If in week A, the part-time worker works 30 hours, the employer is not obliged to pay the overtime rate for these extra 10 hours. The employer may pay the worker at the normal rate for these extra hours or whatever hour rate has been agreed. If in week B, the part-time worker works 45 hours, they should be paid the overtime rate for 5 hours because they have worked 5 hours more than a comparable full-time worker's normal working hours. What hours of work? A part-time worker may already have a term in their contract which gives them a higher rate of pay for any extra hours worked. If the employer tries to reduce this higher rate of pay for these hours in line with the minimum requirement in the regulation, and the worker does not agree to the change, this will be a unilateral variation to the worker's contract, and they can challenge this. More about what a worker can do if the employer wants to vary their contract. So looking at contractual sick pay, maternity pay, or maternity leave, parental leave, and holiday entitlement. A part-time worker must not be treated less favorably than a full-time worker with respect to the rate of contractual sick pay or maternity pay, the length of service required to qualify for payment, the length of time the payment is received. So contractual maternity leave, parental leave, and contractual holiday entitlement must be given to part-time workers on a pro rata basis to that given in full-time workers. Part-time workers must be given the same access to these rights as their full-time colleagues. For example, if the employer gives construction obligation on holiday pay after 1 year's employment, this 1 year qualifying period will apply to both full-time and part-time workers. Thank you so much. Continue watching. Stay tuned. So look at occupational pensions. Occupational pension scheme must treat part-time workers in the same way as full-time workers. This is in respect of both rights of access to pension schemes, unless different treatment is justified on objective ground, and calculation of benefits under the pension scheme on a pro rata basis. More about rights of part-time workers in relation to occupational pensions. Contractual redundancy right. In a redundancy situation, part-time workers should not be treated less favorably than comparable full-time workers unless the treatment can be justified on objective grounds. This means that, for example, the worker should have the same access to help and training to find alternative employment and the same contractual redundancy pay pro rata. What does pro rata mean? Some contractual rights of part-time workers should be calculated on a pro rata basis. This means that these rights are calculated with reference to the hours which the part-time workers work when compared with the hours worked by a comparable full-time worker. So the contractual right which should be calculated on a pro rata basis include contractual holiday and holiday pay above the statutory minimum, contractual maternity pay above the statutory minimum, contractual paternity pay above the statutory minimum, contractual adoption pay above the contractual statutory minimum, contractual shared parental pay above the statutory minimum, and the contractual sick pay, contractual redundancy pay above the statutory minimum. A full-time worker's Christmas bonus payment is calculated on the basis of their full-time hours, say 40 hours per week, and they are contractually entitled to receive £100 per year. If a part-time worker works 20 hours per week, they will be entitled pro rata to £50 hours per week. They will be entitled to pro rata to £50 Christmas bonus payment because they work half the hours of the comparable full-time worker. So when can an employer treat a part-time worker less favorably? Regulations state that a part-time worker should not be discriminated against simply because they are a part-time worker. The different treatment must be able to be justified on some objective grounds. This means that the employer can only treat a part-time worker differently to a comparable full-time worker if they have another valid reason for doing so, which is nothing to do with the fact that they are part-time work. They work part-time. It should not be possible for an employer to claim that there is a blanket valid reason for treating all their part-time workers less favorably than their comparable full-time workers. If a part-time worker considers that their employer may have treated them less favorably than a full-time worker, they can ask their employer for a written statement for the reason for the less favorable treatment. The employer must therefore provide a statement within 21 days of the request. The part-time worker then should compare themselves with a full-time comparator, not a hypothetical one as indicated in this material. What might be objective grounds for less favorable treatment? There is no definition of objective grounds that might be used to justify an employer refusing to give part-time workers the same contractual right as full-time workers until cases have been taken to the UK courts. It will not be clear what might constitute objective ground. Leave a comment below what you think about these types of law and regulations. Look at the government notes produced with the regulations suggesting that one example of objective grounds could be where different hourly rates are paid to a part-time worker than to a full-time worker because there is a performance-related pay scheme in operation in which performance is measured by a fair and consistent appraisal system. Only if the employer could show that the less favorable treatment is because the part-time worker in question does not perform as well as a comparable full-time worker, would this less favorable treatment be justified because it is nothing to do with the fact that the worker works part-time. In one case, the Employment Appeal Tribunal held that if there was a reason other than part-time status for the difference in treatment, then the less favorable treatment could be justified as contained in this material. In this case, the claimant worked part-time and was required to be on a standby for longer than a comparable full-time worker at another station. The difference in standby hours was held to be due to the greater demand in the area in which he worked, not to his part-time status. So we'll look at right to receive a written statement of reasons for less favorable treatment. Stay tuned, continue watching. If a part-time worker considers that their employer may be may have treated them less favorably than the full-time worker, they can ask employer. They can ask their employer for a written statement of the reason for the less favorable treatment. The employer must provide a statement within 21 days of the request as indicated earlier. If the part-time worker takes a case to an employment tribunal about the less favorable treatment, the tribunal may take into account whether the employer has complied with any request for a written statement or has provided a written statement which is evasive about the reason for the less favorable treatment. If the part-time worker has been dismissed and is entitled to a written statement of reasons for dismissal, the above paragraphs do not apply. They should, however, request written reason for dismissal. They must not suffer a detriment as a result of asking for a written statement of reason for less favorable treatment. More about who is entitled to a written reason for dismissal. Part-time workers' entitlement to receive new written statements of terms and conditions. All employees, including part-time ones, are entitled to a written statement of their main terms and conditions of employment. If the employee's terms and conditions change in line with the regulations, the employer should inform the worker in writing of the nature of the change within 1 month of the change coming into effect. In practice, many employees do not have a written statements of terms and conditions. This does not mean that they do not have any contract of employment, merely that the contract they have is verbal and therefore more difficult to prove. More about enforcing an employee's right to a written statement of terms and conditions. How can a part-time worker enforce their contractual right? If a part-time worker believes that they are being treated less favorably than a comparable full-time worker, they can try to negotiate with their employer. The client will often need someone else, for example, the bureau, to negotiate on their behalf. Being part-time need not to be the sole reason the worker is treated less favorably for them to be able to make a complaint. For example, if an employer decided to treat all part-time workers aged over 30 less favorably, they may be discriminating against them because of their part-time status and because of their age. However, being part-time should be the effective and predominant cause of the less favorable treatment. If negotiations with the employer are successful, the worker can enforce their rights through an employment tribunal. If a part-time employee's complaint is that they are being discriminated against because of their part-time status, they should raise a grievance before making a claim to a tribunal if there is a time to do so within the time limit for making a tribunal claim. Looking more at how to negotiate with an employer, more about grievances at work. Looking at enforcing a contractual right through an employment tribunal. Thank you so much for watching Scott. Thank you so much. We have been looking at employment law in the United Kingdom. These laws provide rights which are specific in terms of their principles and implications. We have also seen how employment statuses varies in the United Kingdom. As always, I've suggested if you look at things in the United Kingdom, compare it to your own country, and therefore visiting gov.uk wherever you are in the world online is important, and also all the other recommended websites which are contained in this video. Thank you so much for watching, and we'll see you in the next one. Subscribe if you haven't subscribed. If you have watched, share with family and friends. We'll see you in the next one. Thank you. Bye-bye.
Yabo yora ngara loro pe